Everybody knows the prosecution can't hide the ball, and if they do, there are consequences. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. So we're back today in a case that I covered last year on Jennifer Crumbley. Jennifer Crumbley, you may remember, was the mother of the Oxford, Michigan school shooter. Specifically, I think his name was Ethan Crumbley. We're going to start with this little clip from the judge with her concerns about what's in the reply to the prosecution's response. Basically, one of the things that lawyers sometimes do is they put stuff into a filing in the hopes that the press will run with it, not necessarily that the judge will run with it, and that they'll get a chance to pontificate about it because they knew that there'd be a lot of media interest in this particular case. So this is how the judge handles that little bit.
Good morning. Today's the date time set for defendant Jennifer Crumbley's motion for a judgment of acquittal or in the alternative a new trial. As you're well aware, I have read everything frontwards and backwards and all the cases that you cited. I've read the motion filed by the defense as well as the response by the prosecutor. The court also allowed for the defense to file a reply. The reply of the defense is partially responsive to the response that was filed by the prosecutor, but also contains allegations not supported by the original motion filed by the defense. The reply references a public relations firm allegedly hired by the prosecutor, as well as media outlets shadowing trial preparation at the prosecutor's office. Any argument about PR firms or alleged gag order violations aren't the subject of the motion filed and aren't relevant to the motion filed, although these topics are undoubtedly of great interest to my long-term friends who are from the press and may have some future potential relevance. They do not help me decide this motion. Therefore, I don't want oral arguments on these topics. I am, however, very, very interested in hearing arguments about the proffer.
Let's take a listen to what the counsel, the new counsel for Jennifer Crumbley, said about this issue when he started out.
Mr. Desi, the court is likely in agreement with you that there's been a discovery violation pursuant to MCR 6.201. I guess my real question is, what's the remedy?
Sure. All right. Well, if Your Honor is inclined to, if you're agreeing with my position.
Well, I said likely, you know.
Okay. Well, I guess
my job's to have an open mind, right?
Sure. Well, the reason I'm asking is because the prosecution has made arguments that the proffer agreements were not cooperation agreements, did not confer any sort of immunity, and did not require or offer anything in exchange for these witnesses' testimony. I believe each of those assertions are false, and if the court would like, I would like to walk through the language of the proffer agreement to the extent that the court would like to hear that.
That doesn't tell us too much about what's going on here, but it would appear to be a Brady violation, and it would appear that the judge is interested in that argument. And that's a good thing for Ms. Crumbley, because if she is interested and she finds that there's been a discovery violation, well, then she's got to do something about it. And the something that they want is either a judgment of acquittal or a new trial. Spoiler alert, they are not getting a judgment of acquittal. They might very well get a new trial. Here's the argument on that part.
Sure, that's what I'm interested in. And the 9-page opinion we issued yesterday, I think we discarded some issues that we already felt strongly about after spending an incredible amount of time analyzing them. But I am concerned about the proffer.
Sure, I understand, and
it's not something that I've dealt with a lot before. So
sure. If we could put the screen up, I'd like to show the proffer agreements. That way it would be a little easier for me to walk through the language.
Okay.
And I'm going to ask Mr. Moore to put up Defendant's Exhibit A, which is one of the proffer agreements. And Your Honor, just for the record, the two proffer agreements are identical, so it doesn't matter if we show one or the other. They're the same, all right? They have
First, Mr. Ejak and Mr. Hopkins.
That's correct, for the two school officials. So, all right, just reading from the prosecution's brief, this is their response brief on page 3. this is what the prosecution says. Nowhere is in the agreements is there a grant of immunity or other agreement for testimony. They say there's no consideration in exchange for testimony. And the prosecution also says that it is a gross mischaracterization of the proffer agreements to call them cooperation agreements. So let's just start first by looking at the proffer agreement, just so we can be clear about what the facts are. This is section 2 of the proffer agreement, and it clearly tells us that the purpose of the proffer agreement is to receive truthful information from your client, including information about possible criminal activity by your client and others, to evaluate your client's credibility as a source of information and potential witness. So as soon as the prosecution tells us that this proffer agreement has no effect and was not offered in exchange for any testimony, and it didn't even seek out testimony from them as witnesses, the proffer agreement directly contradicts that by virtue of the language that we can see right there in paragraph 2. So that would be the first thing I would say is the proffer agreement makes clear that it is for the point of evaluating the testimony for these witnesses.
Whether or not they were going to call them as a witness.
Of course, yes.
So do you agree that they could have taken the stand? Mr. Ejek and Mr. Hopkins both could have taken the fifth.
Absolutely, Your Honor.
And violated the order.
They could. Well, yes. And more importantly, now we're jumping a little bit forward to the issue of materiality. But as to the materiality, which we'll get to, the prosecution could not have secured the assistance of these witnesses, period, without the proffer agreements, because these individuals, by their able-bodied counsels, sought out and negotiated these proffer agreements so that they could go in with some assurance or protection that whatever they said couldn't be used against them.
Use immunity?
Use immunity. That's exactly correct, Your Honor. If Mr. Moore can move down on this. So the prosecution has continued to say the agreement doesn't confer any sort of immunity. I mean, it is completely puzzling how they could make that assertion, because right here in 6A paragraph, it says this office will not offer any proper statement made by you or your client in this office's case in chief in any criminal prosecution of your client. What does that mean? It means that those school officials who sat down with the prosecutor's office could say anything they wanted to in that room, knowing whatever they said could not be used against them at any later time. That is a grant of use immunity.
Only if it was true.
Only if it was true. You're correct, Your Honor. Only if it was true.
If they lied, that's wrong.
That's correct. If they lied, then it doesn't. But the point I'm making is the prosecution has gone to great lengths to, in my opinion, gaslight us to tell us this isn't immunity. This is use immunity.
Sometimes it's possible to be too cute. There is no mention of the word immunity in the document. The prosecution's not wrong about that. There's no use of the word immunity or use immunity in there. That's just the truth. But the language used clearly offers a benefit in exchange for the proffer, and that is the kind of thing that could be used to impeach these witnesses. And depriving Jennifer Crumbley of that ability to impeach them by essentially not having her trial attorney stand up and say, you know, you traded your liability, your criminal culpability for Jennifer Crumbley's, didn't you? You decided to sign off on attacking her instead of standing up and admitting that you blew it, that you didn't protect the students, that you and your entire school system are to blame for this. I mean, it's a huge thing to not be able to impeach those people with that. Would it have made any difference in the outcome? Who knows? But depriving her of the chance to use it, that's what the problem is here. Now, at the end of the day, I can't say that it would have made a big difference to me if I was sitting on that jury, that the people from the school had essentially immunity agreements. But I didn't think that they did a good job of proving her criminal culpability as opposed to her husband's. Now, her husband, certainly. And of course, as I recall, they did a lot of really stupid things when this happened. Instead of just saying, hey, you know what? Let's clear our name. Let's stand up and tell the world that we didn't do anything wrong here, that our kid was just, deranged or something. They went and ran and hid out like a couple of small time Bonnie and Clydes. And as a result, they got clobbered with that stuff at trial. Would this have made a difference? Is this the linchpin? Probably not. But again, where you have a Brady violation, you have to tailor the remedy to the violation. And in this case, since those folks got off scot free, there is at least the appearance of impropriety. And frankly, I think the prosecution's office ought to be sanctioned, and the lawyers ought to be sanctioned for making an argument that's clearly not supported by the facts here. But again, I'm not a Michigan judge, thank goodness, and I don't think that there's probably any likelihood that that's going to happen. I think the judge very much wanted to see these people held accountable. Um, some of the rulings in the case would seem to indicate that. That doesn't mean she's a bad judge. That doesn't mean there's anything wrong with that. I'm just saying, based on what I saw, she appeared to be a prosecution judge as opposed to a defense minded judge. And judges have their biases. Nobody is perfect. You can't ever get somebody who is completely neutral. I think the conscience is shocked anytime something like what happened at Oxford High School happens. And so you have to, if you are part of that, you have to bear responsibility for it. That's what I have for you today. A little different than some of the other things I've done, but again, I had done this case back in the day when it happened, and I got a subscriber request to please do something on this particular motion. We'll have to see where it goes. I'll try to follow up on that. And of course, if any of you see that, please let me know. Thanks again for watching. Catch me down here tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.